guys, my name is Alina Shaltsova. I'm an immigration attorney from New York. And today we're going to have discussion on the most recent immigration news. I'm going to update you with regard to an important thing that happened just last week, specifically the revocation of the ICE prosecutorial discretion memo, or prosecutorial discretion, it seems, in general, and what to do in this situation. Not the prosecutorial discretion in general, but the memos, all different memos. The prosecutorial discretion is or cannot be separated from prosecutors or canceled. It's not possible. But the memorandums will be stopped for some time. And I'm also going to talk to you a little bit about the recent Board of Immigration Appeals decision that concerns certain people with regard to their eligibility for cancellation of removal or relief in removal proceedings. So thank you very much for joining me. As always, it's a pleasure to see all of you joining. Please let me know. Let me know how you guys doing. Let me know where you're watching from. Say hello. And we're going to start. Well, first of all, of course, I wanted to talk about very important news, actually. It's the news that taxes prevailed. Taxes prevailed, at least for now, over the Biden administration with regard to prosecutorial discretion. Prosecutorial discretion specifically of ICE agents. We are referring to the memorandum. Here we go. Memorandum that was issued in September of 2021. And that memo basically, it specifies what ICE agents what they have to look at when they're trying to determine what to do with the person who does not have status in the United States. But the whole ordeal is more than that. It's not only about people who can be arrested or not arrested by the ICE agents, not only about people who may be placed in removal proceedings or not. We're also talking about people who are currently in removal proceedings and are seeking prosecutorial discretion, or at least hoping for prosecutorial discretion. What happened, as you know, was that Texas, as a state, sued the Biden administration after the memoranda were issued. And I'm referring to specifically to September 2021 memorandum. But then there is a memorandum, the Doyle memorandum, that went into effect on April 25 of this year. And it's kind of unclear what this decision, what these court proceedings, what effect they're having on the Doyle memorandum. Knowing the way the government operates, I would say that currently prosecutors will be reluctant citing the Doyle memorandum as well. And prosecutors, I'm referring to lawyers who represent the government in removal proceedings, and ICE agents. If you call it, it's like the ICE police or immigration police. So if before or since they had the memorandum, they could exercise their discretion based on specific factors. For example, you are not a danger to public safety or national security, you're a person of good moral character, and so on and so forth. Now it's different. Starting June 24th of this year, because of the litigation, ICE agents cannot take that memorandum into consideration when they're doing their job. However, the good news that they still have some prosecutorial discretion, which they will be exercising on a case-by-case basis. So for a person who is basically without status in the United States, it means that they should consult with an attorney, just as they probably had to do it before. You have to make sure that if something happens to you and you are placed in removal proceedings, you can argue your points with documents such as tax returns, such as positive references, such as records of copies of birth certificates for your children, marriage certificates, ties with the United States communities, business ties, and so on and so forth. And you will have to make a very strong case. It's not enough anymore just to say that you are not danger to public safety or national security, okay? At least for now. We do not know what's going to happen, at least for now. As for those people who are in court, what it means is that you guys will have to, instead of just waiting perhaps for the prosecutors to exercise their prosecutorial discretion, you would have to affirmatively file for one, and you should not be citing any memos that may be challenged, right? I'm talking about the Doyle memo and the September 2021 memos. You should not be citing any memos when you're asking for prosecutorial discretion in court. Why? From personal experience, because I remember something like this happening before. When you just say the words, whatever you have the argument you want to say on behalf of your client, and put some outdated memo in there, a reference to an outdated memo. The first thing that those ICE agents or prosecutors are going to tell you is that, well, this memo is outdated. We cannot make any decision based on that. So just take the references out, make the rest of your arguments, attach whatever documents you wanted to attach, and that's how you're going to have to operate for now, okay? What's going to happen, I do not know, because what was supposed to happen is that the Fifth Circuit was supposed to extend the time during which the Texas judge decision would not go into effect, but they did not, all right? And the Texas judge decision went into effect, and as a result, we are where we are. You have to prepare for the fight in court. As I said, hope for the best, but prepare for the worst. Okay, so that's how it's going to be for now. Maybe as a result of further litigation, things are going to change, but as of now, that's where we are at. Now, another thing I wanted to show you is the Board of Immigration Appeals decision. Yes, and I'm not sure if you'll be able to see it on my screen. You just need to maybe put the screen on max to see it. But it's an important decision. Why it's important? It concerns those people who are hoping for a chance of cancellation or removal, or a chance of fixing their status if their notice to appear did not contain day and time at the time when it was served. This very interesting decision stated that it stated, guys, that if you raise an objection to the lack of date and time in your notice to appear for the first time during the motion to reopen, your objection is not valid. Okay? It gives you a signal that basically you and your lawyer have to act promptly as soon as you find out that something is wrong, and not reserve your arguments until the very end of your case, or perhaps when your case is even lost. Important, especially because it concerns certain procedural rights, but more importantly, the court says that just because your notice to appear did not have day and time, it did not deprive the court of jurisdiction over your case, and the whole proceedings were still valid. It's important because previously Ayla and many attorneys were trying to argue that the fact of the Nis Chavez case from the Supreme Court is not only that the defective notice to appear does not stop accumulation of time for cancellation or removal in the United States, it also deprives the court of the jurisdiction altogether, which actually very logical if you think about this, because if a defective document is served on you, how the court even can have jurisdiction over you if the proceedings were defective at its inception. But courts realize and judges do too, that if this is allowed, then many people will be able to reverse their removal orders. And I guess following this logic, they're stating that the defect cannot be read as jurisdictional. Important decisions, you and your lawyer should know about those, and you should take it into consideration when you are planning on either representing yourself or you just know what's happening in your case and would like to discuss it with your attorney. So that's what's happening currently. And now I have a little bit of time left. I'll be able to answer some of you guys' questions, not everyone's, of course. I see that almost 100 people are watching us, so it's, interesting. Thank you very much that you all are joining. And let me see. Hi, Ajidi, good afternoon. Can judge still be able to terminate and sign my removal proceedings since ICE already agreed and signed to terminate my removal proceedings because I have a pending adjustment of status with USCIS? Honestly, I believe the judge can. Why? Because what happens here is that you received already an agreement from the prosecutor, right? And hopefully your attorney already submitted something before the judge, a motion to dismiss your case. And if both parties agrees, I do not see why the judge should not be able to terminating your proceedings, because the prosecutorial discretion memo, from what I understand, and I believe that this is a correct reading of it, is not concerning the judge's power to terminate or dismiss proceedings or administratively close them. It's only about exercising of prosecutorial discretion by the ICE police or prosecutors. Okay? So I think you should be fine. Hi, Obing. Hi, please. What's the difference between cancellation of removal and termination of asylum proceedings? Two absolutely different things, two different reliefs a person can file for. Cancellation of removal relates, it's a name of a certain process where a person files for a green card. It does not, I know that probably when you read it, cancellation of removal, you feel that your removal is going to be canceled and the proceedings will be closed. But when lawyers speak about cancellation of removal, they usually mean a process by which a person files for a green card with the court. It's not just that your removal proceedings are going to be canceled. If you win your application, you're also going to receive a green card in the end of it. So there are two different types of cancellation of removal. One is for non-permanent residents and one for lawful permanent residents. And I have videos on my YouTube channel and my Facebook. And I have articles on my website, shaltsova.com, my last name.com, that explain the differences between the two types of cancellation of removal. Termination of asylum proceedings is different. Termination of asylum proceedings means that your asylum claim that was pending is going to be dismissed. It's going to be stopped. You are no longer going to have an open or pending claim before the court, and your case will be terminated, means closed, okay? Sometimes it's good, sometimes it's not good, depending on your goals. Hi, Tia. How can I get my immigration case before judges? I think my immigration lawyer made an error for my adjustment of status denial. I wouldn't know, Tia. No one online will know this. A lawyer usually would have to first look at the documents, look at the denial, talk to you, see what your immigration history is, why there was a denial, right? And to be in front of the immigration judge, usually you have to be placed in removal proceedings. Okay, you have to be placed on removal proceedings, which, believe it or not, for people who would like to end up in removal proceedings, sometimes can be very challenging to accomplish, because you have to ask ICE to issue a notice to appear against you, or you have to ask USCIS, so it can be challenging. But definitely seek a consultation with an attorney. Make sure you produce a copy of your denial. Hi, Ali. It's always very nice seeing you. Ali is one of my loyal followers. I think, Ali, you're joining us every time I have live. It's very nice to see you. Any update about undocumented immigration reform? I do not want to upset you, but I have to tell you the truth. I do not know of any positive steps at this time that would deliver immigration reform. Yeah, I will leave it at that. If I hear anything, something positive, I will be absolutely happy to let you guys know. All right. Let me see. Hi, SMT. I'm confused about the policy manual guidelines that was given on June 24th. This is about the 3 and 10-year bars. Will this help those with 2 entries to finally be able to apply for I-601A waiver? I-601A waiver, you could have filed those policy guidelines. I don't think they interfere in any way. I-601A waiver can be filed for only if the only violation that you have here is unlawful presence. It waives unlawful presence. The policy guidelines say that you basically will not have to file for the waiver if you serve your time in the United States, but only for unlawful presence. There are other grounds of inadmissibility that can be applied to you. I don't think that this policy got rid of the permanent bar, okay? Permanent bar applies to somebody, for example, who spends more than 1 year of unlawful presence time in the United States, departs, and then re-enters without authorization, or a person is removed on expedited order of removal or regular order of removal, and then re-enters without authorization, okay? So if you are eligible for I-601A waiver, then that you have to check with an attorney, okay? But the policy change, I don't think it interacts with the I-601A waiver, really. It's more, I think, at least for people who are trying to file for adjustment of status, and in addition to other issues that they may have, they have an issue of unserved bars, or they used to have. Now they say you can serve them in the United States, okay? So that's what I think it is. Yes, thank you, Ali. Thank you very much, Maskin. Thank you. Very, very nice seeing you guys joining, and thank you very much for the kind words. It really encourages me to continue. Okay, the questions just jumped. Hi, Sharkfly. I like your name, Sharkfly. How long does it take a judge to discharge removal proceedings if they believe that my marriage was not bona fide, although it was? Well, listen, what happened? I'm not sure what happened, because whether a marriage is real or not, it's usually decided by USCIS, okay? By USCIS. So what were you filing for that the judge got involved? Usually a question of whether marriage is real or not is decided during the time when you're filing for I-130 form, right? So did you pass the step or not? Or was there an appeal? Or perhaps during the adjustment of status later in court, the judge decided to challenge the determination. I feel like I saw a case where they said that the judge can do it. Sounds crazy, but that's That's, I believe, it does happen. So if you are suspected of having not a real marriage, then the government would charge you with something called 204C, inadmissibility. Or they're going to say that you had a fraudulent marriage, meaning that most likely you will never be able to fix your status in the United States, because no other petition can be approved for you, not self-petition, not petition by your employer or by a new or by a child or by a new spouse. Not possible, right? How long the judge is going to discharge the proceedings, you asked. Well, I don't think there is a dischargement after this determination. Most likely there will be an order of removal, right? Because it means, this whole thing would mean, unless something is missing from my analysis, that you didn't prevail on the application for relief you were asking for. I wouldn't rush, in other words, here with the judge's decision. And of course, you should speak with your attorney and perhaps you have to seek a second opinion. I'm not really sure what specifically happened, but regularly or ordinarily speaking, if a person's marriage is found to be not real by USCIS, a person can appeal this finding with the Board of Immigration Appeals, and perhaps sometimes even ask for review by a federal judge. So guys, thank you very much for watching. It was a pleasure to see all of you. Thank you for joining me. I hope my information was and is helpful. If so, please like and share this video. I will see you soon with more updates, and it was a pleasure.